brands that capture a billion.
The Supreme Court has dismissed pleas to probe the Rafale fighter jet deal with France, blunting the opposition's attack on Prime Minister Narendra Modi and Anil Ambani in the multi-billion-dollar purchase. The Supreme Court's judgment gives a detailed explanation on three key issues raised by a clutch of petitions, namely the decision-making process that led to the deal, the pricing of the fighter planes, and the choice of Reliance Defence as offset partner. At the end of it, the top court found no reason to allow a probe into the Rafale deal. So where does this leave the entire controversy? To speak more on this, I am joined now by a senior advocate in the Supreme Court, Prashant Bhushan, and one of the key petitioners in this case as well. Mr. Bhushan, thank you for speaking with us here at Bloomberg Quint. Now, you've said that you found the Supreme Court's verdict today disappointing. Though the Supreme Court does detail exactly why they came to this conclusion, do you think there was not enough information placed before the Supreme Court, and do you now accept this verdict?
No, we have issued a detailed statement. Arun Shourie, Mr. Yashwant Sinha and I have issued a detailed statement on the Supreme Court's judgment, where we have pointed out that the judgment not only does not deal with the issues raised by us, with the facts pointed out by us, with the prayers made by us. We were only seeking an investigation into the matter. The Supreme Court judgment proceeds as if we are seeking the cancellation of this deal. Not only that, you see, the Supreme Court judgment relies and regurgitates all the facts given to them by the government, either by way of that short open affidavit and mainly by way of some sealed cover which they handed over to the court, which was not shown to us. And it now appears that the government has misled the Supreme Court on several factual counts. The most important being that the CAG has examined the price and has given a report to the PAC, which has thereafter placed the report in Parliament. Now, this is totally false. And I don't understand how the government could have misled the court on such a vital and important thing, which forms the core basis of the Supreme Court's judgment. Secondly, the court says that they examined the Air Force officers in court, who also talked about the process or the procedure followed in the deal, as well as about pricing, which is also totally factually incorrect. The court asked these people only about which was the last plane manufactured in India, and also about whether this Rafale is a third, fourth or fifth generation fighter. There was no discussion at all with these Air Force officers, either on the process by which these planes were purchased or about the pricing, etc. Then the court says that on the issue of the offset contracts, that this Dassault company itself has taken in the offset partner, overlooking a clear provision in the offset guidelines as well as in the defense procurement procedures, which says that no offset contract can be given without the written approval of the Raksha Mantri, that is the defense minister.
Yes.
Moreover, the court makes another factual blunder, saying that from 2012 this Dassault was in negotiation with this parent company of this Anil Ambani's Reliance, which is totally false. This company, this Reliance company with whom this Dassault claims to have been in negotiation, was a Mukesh Ambani company, having absolutely nothing to do with this new Anil Ambani company, which was set up on the eve of this deal, and with whom Dassault entered into an agreement soon thereafter, and about which the French president said that this bringing in of Ambani was only at the instance of the Indian government, and the French had nothing to do with it.
But Mr. Bhushan, the French president withdrew that statement. Hollande withdrew that statement. The court points out to that as well. All of these
he didn't
points,
withdraw that statement.
All these points that you are now talking about, you have clearly presented it before the court. The court has gone through all of this, and then it has come to this agreement. Is it?
No, they didn't deal with any of these things.
No, they have.
The court doesn't deal with any of the points raised by us, which rebut the government's factually incorrect claims. For example, the court says that the earlier deal ran into rough weather because of some disagreement between Dassault and HAL.
Yeah.
Now, we had submitted the video of the CEO of Dassault of 25th March 2015, where he is clearly seen saying in the presence of Air Force and HAL officers that 95% of the price negotiation has been completed. We are going to ink the final contract soon, and we are very happy to work with HAL. Now, how can the court then accept this government statement in the light of this explicit statement on video by the Dassault CEO without even adverting to this statement of the Dassault CEO?
Okay, no, so
I mean, as if all the facts that we had presented
but it
can be just overlooked.
Mr. Bhushan, my point being that no one can speak for what was in the minds of the Supreme Court judges and the Chief Justice who was, heading this bench. I'm just presenting to you the simple fact that all of these things you've said, you presented before the court. They were presented with another set, of points by the government, and they have looked at both and they've come to this decision. Is that not enough for you now to drop this, or will you go for a review petition?
No, I mean, court judgments are often wrong. We have seen them to be often grotesquely wrong, and in this case there are obvious grotesque factual errors. How does the court count? What basis does the court write that there is a CAG report? Government never said that. It was never claimed either publicly or in any record of the court. How does the court reach this conclusion, and a totally factually false conclusion, that a CAG report has been given on the Rafale pricing to the PAC, and PAC has thereafter placed it in Parliament?
No, so okay, let's go on it, to it point by point on the decision-making process. Just to pick of the key things that the court says, they say even if minor deviations have occurred, that would not result in either setting aside the contract or requiring a detailed scrutiny by the court. They also say we cannot sit in judgment over the wisdom of deciding to go for 36 in place of 126. We cannot possibly compel the government to go and purchase of 126 aircrafts. That seems reasonable, Mr. Bhushan. And the court also banks on what the country needed at that point in terms of defense.
You see, we were not seeking the cancellation of the contract. We were only seeking an investigation. And we pointed out that the defense procurement procedure laid down in black and white by the government requires that first the Air Force headquarters have to give its requirement. They gave their requirement of minimum 126 planes. Thereafter, the Defense Acquisition Council has to decide how many planes and where to get them from. They decided that 126 planes, out of which 18 will be purchased in a ready-to-fly condition, 108 would be manufactured in India by HAL with transfer of technology for self-reliance. Now, all this was just thrown out of the window by the Prime Minister himself on 10th April 2015 when he signed a completely fresh deal with the French President without going through even the basic process. Nobody, no Air Force had asked the government that, all right, now forget 126, give us only 36. No Defense Acquisition Council had said that, all right, forget transfer of technology, forget Make in India, buy everything ready-made.
Again.
They have made a mockery of this whole thing.
Again, I come back to the point. The court says today that even if minor deviations have occurred, they would not result in either setting aside the contract, which you said you've not asked for, or a detailed scrutiny by the court, which you have asked for. Moreover, on pricing, they say it's not the job of the court to carry out the comparison.
I'm not asking for a detailed scrutiny by the court. I am not asking for a detailed scrutiny to be carried on by the court. I am saying that let the CBI investigate it under the monitoring of the court. Because these facts, you see, it's not minor. What is minor in this deviation? You have changed a almost done deal of 126 aircrafts, where only 18 were to come in ready-to-fly condition, 108 were to be manufactured in India under transfer of technology.
Mr. Bhushan, these arguments, sir, I know these arguments, they have been reiterated in conversations you and I have had several times. The point is now what happens from here on, because at the end of all of this, the court does say that perception of individuals cannot be the basis of a fishing and roving inquiry, especially in such matters. They have effectively said either we don't have the jurisdiction on some aspects like pricing, etc., or they've chosen to go with what the government is saying, and at the end of the day, they're saying that, we don't think there should be an inquiry, which is what you went and asked for. My question to you is, what happens now to the Rafale deal and your campaign about the Rafale deal? Do you continue? Do you go in for a review? What's the next step?
Well, the court's judgment is totally wrong, and therefore, it contains many factual errors which are apparent on the face of the record. That's a good ground for getting the judgment reviewed. We will file a review petition, but what they do, because the same judges examine the review petition, what they will do to the review petition we can't say, but as I said, you see, the court is not always right, and we have seen this even in the Birla Sahara case or even in the Bofors case, where corruption in high places is involved. The court often sort of becomes soft on seeking an independent investigation into such matters. And therefore, on this Rafale issue, firstly, none of the questions that we have raised has been addressed in this judgment. Secondly, they have not even dealt with those issues. Secondly, every day new information is coming out. Today, for example, Caravan has carried a detailed story pointing out how it was Mr. Modi himself, as head of the Cabinet Committee on Security, who raised the benchmark price from 5.2 billion to 8.2 billion of these 36 aircraft.
Okay, so you will go in for a review petition.
Irregular.
You will go in for a review petition, you are saying. Now, let me come to the other part of this. There are some who are saying that the court was not perhaps the right forum for this. Let me read out to you what the Congress party spokesperson Randeep Singh Surjewala, he's retweeted a 14th September tweet of his, in which he said, "We reject the BJP-sponsored PIL on Rafale scam, which has been instituted so as to misdirect and derail investigation into the various facets of Rafale scam. We shall continue to press for a JPC probe on Rafale scam." Now, your position on Rafale is often, Mr. Bhushan, seen in conjunction with that of the Congress. Today, in fact, in a press conference, a senior BJP leader referred to your petition and the petitioners involved as the B team of the Congress. Where do you find yourself in this political fight which is also brewing over Rafale?
You see, we were also not in favor of going to the court on this issue, but when two sponsored petitions were filed, one by ML Sharma, one by Vineet Dhanda, on which the court asked the government to file the details of the procedures in a sealed cover, etc., then we thought that once the court has entertained a bogus petition, a proper petition should be filed. earlier we had decided that we would not approach the court in this matter, because having seen what was done in the Birla Sahara case, we have seen that by and large courts are very reluctant to order an investigation into people sitting in high positions on a matter of corruption. That happens very, very rarely. So therefore, we were also very reluctant to do this, but we entered only after the court had already issued notice to the government asking them to file something in a sealed cover. And on the basis of a sealed cover, which is not even shown to us on this pricing, etc., as to what it contains, they just pass a judgment saying that we feel that there is no need for...
Are you working in conjunction or is there any coordination with the Congress campaign on Rafale, Mr. Bhushan, or is that a separate thing altogether?
Pardon?
Are you working in conjunction or is there any coordination with the Congress campaign on Rafale?
No, I'm not working in coordination at all. We do our own thing, they do their own thing.
What about the demand for a JPC now into Rafale? Do you think that's the next logical step?
You see, there will have to be, firstly, there needs to be transparency in this. This whole business of secrecy, that we will not reveal any pricing details, we will not reveal the details of how the benchmark price was increased, we will not reveal how they arrived at 36, etc., from 126 down to 36, whether the Air Force told them that all right, now just give us 36, etc. When did the Air Force tell them? The government is not willing to reveal any of this. First, they must put out these facts in the public domain, and secondly, there must be an independent investigation into this. This judgment is not going to put a quietus to this.
All right. Thank you for speaking with us, Mr. Bhushan, and explaining your stance on the Rafale deal.